get started. Hi, everyone. Thanks for coming today. Firstly, I'd like to acknowledge the traditional owners of the land and their leaders, past and present. Just a general disclaimer, today we'll be covering why privacy is a whole of enterprise risk. We're just going to be giving general information, so if you need any tailored legal advice, please, of course, contact your lawyer. So firstly, some introductions. My name's Katie. I'm a commercial lawyer at Law Squared with an interest in privacy.
Hi, my name is James Cole. I'm special counsel at Albrook Burroughs, specializing in cyber data protection and privacy.
So this is our agenda for today. You can see that we'll be covering a few different topics that will all come together as to why privacy is a whole of enterprise risk. Firstly, I'll introduce our topic. So James and I were talking about this, and we thought that it's important to cover why privacy is a responsibility for the whole of the company. And this is because it often is the responsibility of the IT team, or it falls to the responsibility of the IT team, when really it should be led from the top of the management, including the board and directors, C-suite, et cetera, down. There should be tailored privacy obligations for all staff in the company. We also wanted to cover the importance of the general counsel and external legal counsel and how we can help in not just being that voice that says no or when something goes wrong, but also when you want to, release a new service offering or to help a company just be compliant from the start. So we're going to start with some basics so that we're all on the same page today. What is personal information? You're going to hear us say this term a lot. So personal information is any information or opinion about an individual that may reasonably identify an individual. So as you can already see from reading that definition, privacy is all about individuals and how organizations handle the personal information about individuals. Here's some examples of personal information: name, contact details, photographs, IP address, and geolocation information. Those are all ones that we'd probably already know, but a less commonly known one would be commentary or opinions about the person, whether they're true or not. Here's some other pieces about personal information. So one piece of personal information can also infer other information about that person. This is enhanced when there's access to other information about the person. So the OAIC, which is the Australian privacy regulator, has released some guidance that the more touch points of data you have about an individual, the more likely they are to be reasonably identifiable. What can you infer about a person from their email address, let's say? And this goes to why one piece of personal information can tell you more about them than just their email address. So let's say we have Bob Smith from Westpac. His email address is bsmith@westpac.com. You look at that, you can already see his name's Mr. Smith. He has or currently is working at Westpac. Let's say you enter that into Google. Now you can probably find his LinkedIn and a whole host of information on that LinkedIn, whatever he wanted to put on it, and maybe a company profile for him as well. A subset of personal information is sensitive information. And we've put some examples on this slide. I'll just give you a moment to read it. You can see the first few points are ones that are pretty common and ones that we would think about, when we think of information that's more sensitive about an individual, but a less commonly known one would be professional associations and trade union memberships. Professional associations could be something like a Law Institute of Victoria membership. So just from reading that list, you can see why sensitive information needs to be handled carefully and why it has higher levels of protection under the Australian privacy laws. It often portrays more intimate details about individuals, and it also poses larger risks to individuals if it's subject to unauthorized access, disclosure, or loss. Under the Privacy Act, organizations must seek consent from individuals when collecting, using, or disclosing their sensitive information. So what is the Privacy Act? It's the main piece of national legislation that oversees the handling of personal information in Australia. It applies to Australian government agencies, private companies, or NFPs with a turnover of over 3 million. It's important to know that turnover is not the same as revenue. Turnover means income from all sources. The Privacy Act also applies to health providers and small companies that opt into the Privacy Act or handle certain types of information. The Privacy Act regulates how organizations can collect, use, store, and disclose personal information. It's also important to know that there are state-level privacy acts and health records acts that may apply to particular organizations. So it's important to know what acts and what state laws you need to comply with in addition to the Privacy Act.
But now that we've established what privacy is and what the Privacy Act is, who's responsible for it? As we mentioned at the beginning, privacy is not just for the IT team. It is a responsibility of the whole of the organization as an enterprise risk driven from the top down. The directors, C-suite, employees, they're all acting as agents of the business and have general obligations across privacy, as well as specific duties that can arise from specific acts of legislation, such as the Corporations Act. Middle management have a role to play in implementing privacy across the organization, as well as frontline staff in getting involved in assessing how information is handled across the organization and informing their line managers and the leadership. Higher levels of management, such as general counsels and C-suite, act commonly as the champions of privacy across the organization. They take responsibility for the privacy risk management, setting the tone for the cybersecurity management, and implementing frameworks across the organization. Increasingly, we're seeing organizations appoint specific people outside of the normal chains that you would see, such as the IT suite and the risk management suite, dedicated to privacy, such as chief information officers, chief privacy officers, or privacy champions, or even appointing external resources such as data protection officers or external specialists. The corporations typically manage privacy using a wide variety of resources. Two common ways to start are mapping what privacy information you have so that you know what you have, where you collected it, why you collected it, where you're storing it, how you're processing it, why you're disclosing it, as well as creating a privacy impact assessment. Privacy impact assessments are recognized by the OAIC as well as every privacy regulator in most countries as a way of assessing the overall risk to individuals and their personal information as you handle it across your various systems and projects. Additionally, it's worth noting that the Corporations Act does bring about specific duties for directors in respect of privacy and cybersecurity. There are requirements for effective management of privacy risks and cybersecurity risks as part of core governance of the corporation. These requirements extend into what is considered to be a proper or baseline standard of cybersecurity. It's important to ensure that directors are exercising reasonable care and diligence in ensuring your compliance with the Privacy Act and other forms of legislation around cybersecurity and privacy. As we'll dive into a little bit more depth, you will see that ASIC has a very large role to play when it comes to privacy and due diligence of cybersecurity. ASIC has recognized that cyber risk is a crucial part of the role of the board and often expects boards to be spending dedicated time on this topic. ASIC has also released guidance specifically around board activities for cybersecurity and privacy, including the dedicated meetings around that. We've also seen specific guidance around the minimum cybersecurity requirements for anyone who holds an Australian financial services license. this can add additional responsibilities and obligations for senior management around privacy compliance. A recent matter that came through the courts, with judgment just being handed down last week on the 5th of May, was ASIC's first prosecution under the general obligations for an AFSL holder in respect of breaches of cybersecurity. In this case, RI Advice Group was prosecuted by ASIC, and they came to a court-approved settlement, which showed that there were significant deficiencies across RI Group's cybersecurity risk management. Very sensitive information about clients was leaked through a series of breaches where RI Group's cyber risk posture was not up to a baseline standard. It's important to note that the federal court did signal clear language of their disapproval of RI's failures to adequately address cybersecurity risks, and this could lead to increased regulatory action in the future. The cyber incidents that RI Advice Group was prosecuted failing to implement included a lack of patching their systems, no email spam filtering, inadequate backups, no or inadequate endpoint security software, and sharing passwords and using default passwords across systems. Additionally, it was identified that RI Group had failed to properly document the governance around the cybersecurity controls and their policies. They relied heavily on parent organization templates rather than customizing to the unique needs of their entity. RI Group was ordered by the federal court to engage a cybersecurity expert to improve their cybersecurity resiliency within 90 days, to provide ASIC with written reports about the cybersecurity measures they were implementing, and to pay ASIC's legal costs up to $750,000. The general responsibility of general counsels and external legal counsels is an interesting area. Lawyers are often seen almost as a roadblock, a naysayer in doing things, and that's just not the case. We're not there to say no. Lawyers are there to help to guide you through achieving your business goals and objectives in a way that is legally compliant. General counsels and external specialists can help in developing, rolling out any new service offerings, conducting internal privacy practice assessments and risk assessments, and identifying legal risks and obligations across the organization, as well as help you when things do go wrong and you have a data breach. Compliance at an early stage is significantly better than going into a data breach. So it's certainly risk management. It should be a top priority for management. As we're seeing with 2022, this is a year where regulations are getting more and more intense around cybersecurity and privacy. When we say regulators in Australia, we commonly speak about the Office of the Australian Information Commissioner as the primary regulator for privacy. But as we've seen, ASIC has a role to play. APRA has a significant role to play in their regulated entities. ACMA, the Australian Communications Media Authority, is responsible for the Spam Act, as well as regulating broadcasters and privacy and cybersecurity across their industry. And the ACCC is also getting into the mix. They are looking at issues around misleading and deceptive conduct in privacy declarations. Most regulators do have some form of privacy regulation and cybersecurity regulation.
So your business, and you're doing business domestically and also internationally. What are some considerations that you need to have? Some of the basic considerations that companies need to think about is where are you collecting personal information from? Are you collecting it in Australia, the US, EU, UK, Asia? Where are you collecting it from? Because this will influence the obligations you have under the privacy laws. What entities are you sharing the information with, and what are their operations? So for example, let's say you use Amazon Web Services as a cloud service provider to store various pieces of data. Where is Amazon Web Services based? What are their operations? That will influence your compliance with the privacy laws. What entities are you sharing information with you, and what are their operations? So let's say you have corporate customers sharing the information of their employees with you. Where are those customers based, and where are those individuals, the employees, based as well? Under the Australian Privacy Act for international transfers, Australian businesses have particular obligations. The business must ensure that the overseas entity that it's sharing information with will provide the same protections as those under the Privacy Act. The Australian business is also responsible for the overseas entity's compliance with the Privacy Act if it shares information with them. So this means that if that cloud services provider doesn't handle the personal information that you've given to them correctly or in compliance with the Privacy Act, you're also at risk. How do you know if you have any international privacy obligations? Organizations need to be aware of when they pull it in. And some common examples that our clients deal with are the EU or UK General Data Protection Regulation, the US privacy laws, New Zealand privacy laws, and privacy laws in Asia. It's important to note that the New Zealand privacy laws are actually pulled in by Australian businesses a lot more often than we think. And the New Zealand laws are adequate with the GDPR, which means that the requirements under them are a lot more stringent than the current Australian requirements. An example that we'll go through now is the GDPR. The GDPR is regarded as the strictest privacy regime in the world and contains obligations for organizations that do one of these two things: offer services to individuals in the UK or EU, or have an establishment in the UK or EU. It's important to know that the threshold to meet these requirements for online businesses is generally lower. The GDPR can also be pulled in by merely dealing with a company that has to be GDPR compliant. So if you're an Australian business dealing with another Australian business that has to be compliant with the GDPR, you may now also need to be GDPR compliant. The US is a complicated regime, as privacy is generally regulated state by state or by sector. So what are some practical tips for organizations to put into place to manage your privacy? Some comedic relief. Phishing is a common risk that comes, for example, through emails. I think a lot of us here have received a phishing email along the way. So it's important to think about when you receive an email, is this from, who it says it's from? Maybe don't click on that link that asks you to give your financial details, stuff like that. And is that a moon that you really want to be going to? What are some practical tips for staff? They need to recognize when they're handling personal information. They should know what information the company generally collects. They should only use personal information for the reason it was collected and store it safely and securely. They should use strong passwords or a password management system like LastPass, for example, and use multi-factor authentication. Some simple don'ts. Staff shouldn't disclose personal information to another staff member who doesn't need to know about it. They shouldn't disclose it to people outside of the company or use the same password across different accounts. Write personal information on loose leaf paper or keep it longer than it was needed for. What are some practical tips for companies? Companies should have strong internal policies regarding privacy and cybersecurity. And this is important to note that these internal policies should be based on that company's specific operations, service offerings, who it's regulated by. And these policies should be regularly updated and revisited. It's not a set and forget situation. You need to be updating them every 6 months or in line with updates to the law. And staff should also be provided with privacy training tailored to their position at all levels. This is important to know with the training because there are some privacy regulators that will actually ask you if you have to report a data breach if you have provided your staff with privacy training.
Does this count as my privacy training?
Sure. So companies should know what personal information they're collecting and why they're collecting it. Companies have obligations under the Privacy Act to only collect personal information that is reasonably necessary for its functions and activities, and they have a positive obligation to justify that their collection is reasonably necessary. They should be aware of the personal information they actually collect. There are some pitfalls that come up in data breaches, for example, where you have a web form where you collect name, email address, telephone number, but then you have, that comments box where you can enter whatever you want into it. That's just a gold mine of personal information where they can enter anything. The OAIC is cracking down on companies that have collected personal information that was not necessary for their operations or when they keep it for longer than necessary. So a recent example is a case involving 7-Eleven. They had an in-store survey and they had, people coming into the store and filling out this survey on an iPad. What wasn't so apparent to the people filling out the survey was that the iPad was taking images of their faces while they were filling in this survey. Images of faces are considered biometric data, which is sensitive information under the Privacy Act. It was found by the OAIC that 7-Eleven really had no reason to be collecting images of people's faces while they were doing that survey. 7-Eleven said they wanted to take images of people's faces so that they could find out, how truthful they were being or consistency, which I think if you give it a pub test, you'd find that, you don't really need someone's face for them to fill out a survey. Organizations should also have an effective data lifecycle management process. We often have clients approach us that say, cool, I've collected this personal information. How long do I keep it for? 2 years, 3 years, 5 years? How long do I keep it for? It's important to know that under some of the Health Records Acts, there is a specific requirement to keep personal information for a particular amount of time. But under the Privacy Act, there is no set amount of time that you need to keep personal information for. Clients are often disappointed when we tell them this, but the reality is, under the Privacy Act, you're required to destroy or de-identify personal information when it's no longer needed for the original purpose it was collected for, and that could be any amount of time. Let's say you're doing a trial service offering where you haven't previously collected people's addresses, but now you are. Once you finish that trial service offering or gotten, the findings you needed from that information that you collected, you should be deleting that address information. Companies should also have an effective data lifecycle process. They need to know when they're collecting personal information, where from, how long, what for, and when they delete it. And again, with this, it's not a set and forget. Data retention practices need to be revisited regularly, and even more so if your service offerings are often changing.
So what are the risks and consequences if you have a data breach? First, what is a data breach? A data breach occurs whenever any personal information is the subject of an unauthorized access, disclosure, or loss. It's a common misunderstanding that the threshold is that information has been stolen by a hacker and published. Yes, that is a data breach. But IT accessing HR records without a legitimate business purpose is also a data breach. CCing instead of BCCing on a large distribution is also a data breach. So what do you do if you suspect you've had a breach? The first thing to do is to contain the breach as quickly as you can. That can be as simple as changing passwords and kicking the hacker out, or containing that information as best as possible. Second, and generally in parallel, contact specialist forensics and legal support. This is a very complicated area that can bring a lot of unique obligations into scope and often requires specialist services to assist. If your business is covered by the Privacy Act, and you've had a data breach or you suspect that you've had a data breach, you need to do an assessment to determine what information was involved, because if there is any likelihood that a risk of serious harm could occur to the affected individuals, you will have to notify the Office of the Australian Information Commissioner, as well as possibly notify the affected individuals. And additionally, you may have wider obligations in other jurisdictions as well that could come into scope. A few statistics from the OAIC's Notifiable Data Breach Report from July to December last year showed that malicious or criminal activity amounted to 55% of the breaches that were reported to them. System faults accounted for 4%, and human error inside the organization was 41%, with the most common human error being personal information being emailed to the wrong recipient. Little practical tip, you can put a 1-minute delay on your outbox in your email, and that can often save you in that 1 minute of reflection after you hit send. Commonly breached information includes contact information, such as name, email address, postal address, identity information, such as driver's licenses, passports, dates of birth, birth certificates, marriage certificates, banking information, super accounts, credit card numbers, health information, as well as tax file numbers, noting the fact that tax file numbers also have a special form of treatment under the Privacy Act and stricter criteria. So what are some examples of data breaches? Losing a USB device on a train that has sales information. That would be a breach. Or losing an iPad or your laptop or your phone. If an email is sent to the wrong recipient, such as you meant to send it to Jane Smith and you sent it to Jane Smythe, that is a data breach. We often see breaches where something has been accidentally deleted, such as IT accidentally deleting a database, technical errors resulting in publication of personal information on public sites, and a very common one being the email hack. Clicking on a wrong link, hacker gets into your email and copies your entire mailbox. So what can you do to plan ahead for breaches? It's important to have a data breach response plan or incident response plan in place and to practice it regularly. You do not want a real data breach to be the first time that your staff see that plan and work through how to use it. So certainly practice it regularly. It does come up when you report breaches, whether or not you had one of these plans and you practiced it. Have in place and enforce IT and cybersecurity policies, implement training, and have contact details for specialist forensics providers that can help you in the event of a breach and investigating that breach. So if you do suspect that you've had a breach, you should notify your supervisor or manager about what has happened immediately. Or if you are the supervisor or manager, call legal. Try to contain the breach as soon as possible. Engage your IT staff, engage that cyber forensics specialist that you've got on speed dial. Assess the extent of the breach. So you want to try and figure out how many people and to what extent they were impacted. And let your general counsel and external legal team know. Again, call legal. So what are some of the risks and consequences of the privacy laws and breaches? Well, if you get it wrong, Organizations can face significant fines, long-term business disruption, investigations by regulators, reputational harm that could result in lost business, litigations, and find that it's difficult to renew or even obtain any form of cyber insurance, or it will get renewed on very unfavorable terms. Staff can also face fines or disciplinary action if they were involved in the breach and it was malicious in any way. It's important to note that the privacy laws in Australia and globally are changing rapidly. This is a year where we have seen virtually every law in privacy get updated. And Australia is no exception. The Privacy Act for Australia is undergoing a review for modernization and amendment. There were public consultations earlier this year that have now closed, and it is expected that we will see a new version of the Privacy Act within the next year, and that it will closely align to the requirements of the GDPR, which would bring us in line with the privacy regime in New Zealand. There has also been updates to the consumer data right for financial services and telecommunications company, with additional stages being rolled out and financial services already being rolled into the CDR, with energy sector being rolled out in November. We're also seeing increased regulation from various regulators such as ASIC, ACCC, and APRA. APRA is expected to release new guidance for cybersecurity and privacy later this year. We've seen the ASIC case against RI Advice, and ACCC decided to prosecute Google in respect of their privacy statements. The federal court found that Google engaged in misleading conduct and had made false representations in relation to their privacy statements and the way that they collect and use personal information. The language, the form, and presentation of your privacy statements, collection notices, and privacy settings is important. The Australian consumer law does apply to privacy statements. It can be deemed to be misleading and deceptive conduct if you fail to disclose the way you handle personal information or any form of processing as part of those privacy statements.
So thanks for listening, everyone. Now we're up to the question part, if anyone has any questions.
I have a question,
Yes.
non-lawyer question, but a marketing question. So obviously Law Squared has a huge database that we send our newsletters to every month, and then when we move to the UK and we have more people subscribing from the UK to different comms, do we have to have, are we allowed to send the same Australian comms to the people in the UK and vice versa, or we have to keep them separate?
There's different consent requirements for individuals to receive marketing communications under the GDPR in general. So in Australia, you can have implied consent to use someone's personal information. So my opinion would be with the UK individuals, you would probably need to have them tick a box or say, yes, you can send me marketing communications. And then it's also important to have that little unsubscribe piece at the bottom of the communication so that they don't get any more if they don't want to.
So we can send from both, or it can be just Law Squared, but it can go to a UK database and an Australian database?
Yeah, I'd say so. You just need to get consent from those UK individuals.
Okay.
Do you have anything to add, James?
Yeah, under the GDPR, yes, you need that positive consent. So it cannot be a pre-check box that you have to uncheck or opt out of. It must be an opt-in mechanism that requires them to take an action to actually click something. And also often neglected, but showing itself in the courts quite a lot, you have to be able to prove that you obtained that consent at any later date. So that consent management becomes more important as well.
Yeah, whilst you could send the same communication, the actual process for getting like the UK people to say yes to getting that communication would be different to the Australian ones. So it's like that front end part.
Yeah. Okay. Thank you.
So Katie, as you know, the company I work for has heaps of exposure to GDPR and various wacky US state privacy laws. But I was interested and scared when you talked about New Zealand laws. So I had no idea, we just kind of ignore them and assume if we're doing the Australian, covering the Australian things in GDPR, then we've kind of got it covered. But just how tough are they? And have we seen any instances of New Zealand regulators coming after Australian companies?
They have that same 72-hour notification timeframe as the GDPR does for a data breach. I'm not sure about instances of the New Zealand regulator coming after companies, but James, do you have any?
I have had a few where they're more than willing to take any kind of action. In particular, they are quite almost religious about the 72-hour notification window. If New Zealanders' information is involved and you cross that 72-hour threshold, there are penalties that apply, and they are quite willing to enforce those on Australian companies.
A follow-up question, sorry. So worst case scenario, we've had a data breach. You've only got 72 hours, so we're not able to, let's say maybe a lot of our customers or sales channel are involved. We don't have time to go through and work out what country they all came from. Should we be considering just notifying every privacy commissioner that we can think of that there's been a breach or potential breach of this customer data? I mean, we usually focus on the European ones just because they have a shorter time frame, and up until 5 minutes ago, I thought the highest penalties. So do you recommend, or would you recommend, maybe it's context specific, that you just go, you know what, fine, we're notifying Australia, New Zealand, everybody?
Yeah, I think there's a context specific element to it, but you know, under the GDPR, for example, you have that time, you have that sort of one excuse that, you know, you were just trying to figure out who is affected in a bit of a delay for that 72 hours. But New Zealand could be a little bit stricter, James?
Yes, New Zealand tends to take the view that if you know that you've got New Zealand clients in this and the systems affected have personal information or process personal information in any way, then you ought to at least suspect that New Zealanders are involved, and that's immediately triggered that 72 hours there. That's where you really, the importance of quickly getting a response team in place that has those specialist capabilities helps a lot because there are processes and systems that can be used to rapidly identify groups of individuals that are affected and the types of information. But it also puts a little bit more emphasis on the idea of risk management and knowing what information you have, where it is, and how you use it. And that's that data mapping exercise and the privacy impact assessment exercise.
I have another question, sorry.
Yeah.
It's marketing related. Similar to that, in my last job, one of my assistants accidentally put a 500,000 plus mailing list into CC instead of BCC. And we did nothing about it. What, in that situation, were we meant to have notified those people to say sorry, or what do you do if that happens? Because that's like an easy mistake that happens quite a lot.
Yeah, and I think that's one of the reasons why we mentioned it as well, because you just kind of don't think about that accidental CC until, you know, the annoying lawyers are like, oh, you should watch out for that. So I think some practical steps for that would be you try to, you know, what is it, like recall the email. That doesn't always work.
Yeah.
You can then ask the recipient to delete that email from both their inbox and their deleted box. And then you probably need to conduct that assessment about,
Yeah.
the risks to those individuals and whether you need to notify the Office of the Australian Information Commissioner and or the individuals. It would be a sort of context-specific situation.
Yeah, okay.
Yeah, exactly. It's all based on the information that's in there and what actions you could take in recalling that. Again, I would strongly suggest that 1 minute delay on your outbox gives you that moment of reflection.
It wasn't me, I swear.
No, don't doubt it. Personally, I would love it if every company had their IT department just roll that delay onto everybody, because that would help to reduce that 41%, I believe it was, human error.
Yeah.
Should come up with a pop-up box saying, "You sure you want to send this?"
Yeah.
Any other questions?
Yeah, so that case where ASIC took action against RI,
Yes.
so was that purely a function of those powers come in or those standards come in purely because it was an AFSL holder? Because I guess the interaction between security and privacy, basically every privacy law that I've dealt with is pretty vague about what level of security you need, which sort of makes sense because security is always changing and it's sort of an arms race between security and the hackers. But it seemed from those dot points that ASIC had some pretty specific ideas about the standards and that RI had not breached those. So in that, does that law contain more specific standards about privacy and therefore, about security? And is that maybe helpful for companies that, even if they're not AFSL holders, if the court has now finally decided on what some of these standards might need to be?
Yeah, I think there are definitely some takeaways from that case for, that all companies could use, but it was under Section 912A of the Corps Act, specifically to do with that AFSL for that case. But like those principles that we were going through about, not having patched backups, not having the appropriate security methods in place and all those sort of pro tips were helpful. But yeah, James, would you say the same?
Yeah, I would. That particular prosecution was around 912A, which specifically relates to general obligations for AFSL holders. And ASIC's really good at putting out guidance pretty quickly, so I'm sure that they will probably publish some cybersecurity guidance around their expectations and that particular case. They did outline very specific cybersecurity controls in their statement of claim to the court, which the court has accepted. The real signal there is essentially that we're likely to see other regulators and industry bodies start to align more to specific standards of cybersecurity and what is considered to be an appropriate minimum posture. It's also important to note that those particular items that we mentioned, they're about RI advice's cybersecurity deficiencies. The regulators like the OAIC will commonly use those baseline kind of best practice standards to say whether they want to escalate into an investigation of a breach or not. So if you tell them, yeah, we had this incident, we had no backups because we just don't do that, they're not going to be happy. They're going to escalate that pretty quickly. So it's generally a good idea to kind of align to an industry best practice that aligns to your particular industry. And if you have none, align to some of the best practices that are out there, like ASD's Essential 8 or an international standard such as NIST or ISO.
I don't have any more questions, I swear. If there's no more questions online, then we can.
I do have one more.
Yeah, go for it.
Another thing that was new information to me, and that might be really useful, is the fact that directors, like that, they have specific duties about bringing the company up into line on privacy. And I'm figuring on using that to beat up on my company's directors to get the resources that we need. But where do you see the role of like internal legal? They're not advising the directors. They're not the directors' lawyers. Can you just sort of thrash them with it, or should one tread carefully this afternoon when they meet with the directors? Not to get too specific.
What do you think, James?
I think ultimately, yes, you are. If you're the general counsel, yes, your duty is to the organization. I think we're starting to see a little bit. I do a lot of work with insurance, and we're starting to see a little bit more knock-on effect to directors' liability insurance on that. So it's a question of really kind of outlining, look, these are the obligations that exist. This is the duty that you need to consider, and the guidance that's out there from the regulators. We need to address this risk. And I often see organizations escalate that through their risk management frameworks, clearly identifying privacy and cybersecurity as individual enterprise risks that then require treatment under your regular risk management framework. And then that sort of brings it into the board discussion.
Yeah, I feel like we've got that far. I would just, I love the idea of making it a little more personal for the decision makers. But message received. I'll be careful about about that aspect of it.
Okay.
Thanks for coming, everyone.
Thank you.
Thank you so much. I learned a lot today. Gosh, I'm going to be a lawyer in no time. I'm joking.
Thanks, James.
Thank you.
Thanks, James. Thanks, Katie. Stop
Can I hang
recording.
up?